Good morning, my name is Beata Polok, and today I would like to discuss the topic, the rights of refugees. So as we all know, the main responsibility for protecting human rights lies on the state. State is responsible to protect our rights and respect our freedoms. Human rights law works on the assumption that the state is the abuser of our rights and that treaties and custom prohibit the state from certain activities or require the states to do certain things. Sometimes, unfortunately, it happens that state cannot protect our rights, that the state fail to protect our rights, like for example, during civil war. Universal Declaration of Human Rights in Article 14 states that everyone has the right to seek and to enjoy in other countries asylum from persecution. The meaning of this provision, however, is very unclear. Currently, the three main sources of refugee law, of international law, because we have also regional law protecting the refugees, but today we will discuss only international law, are the 1951 Convention, 1967 Protocol, and non-refoulement rule. We have, of course, different resolution issued, for example, by General Assembly related to the situation of refugees, but this form the so-called soft law. Starting from the 1951 Convention, the convention was created to address a particular problem. It was the problem which appeared in Europe in the post-war period. According to the convention, it applies only to individuals who became refugees as a result of events occurring in Europe before 1st January 1951, and was designed to assist in the resettlement of persons displaced as a result of the Second World War. Today, around 144 states are party to this convention. The second protocol, the 1967 protocol, the second source of the refugee law, removes this geographical and temporal limits of the convention for those who have accepted it. So as explained, the date 1951, when we will look at the Refugee Convention at the Article 1, which contains the definition of the refugee, we will notice two things. We will notice the time limitation. We will also notice the geographical limitation. The year 1951 is significant because it shows that state parties who were involved in drafting the convention were keen to limit their liability to people who had been made refugees during Second World War, and also includes only events that had already happened. States did not want the convention to create open-ended responsibility for refugees. That would be an ongoing indefinite burden on national governments. With the adoption, as I mentioned before, the 1967 protocol, the definition of the refugee from 1951 convention lost most of its significance. It is relevant, however, to those countries who have signed convention but did not sign the protocol. So today, we would like to explain who is a migrant, who is the asylum seeker, and who is the refugee. At the end, we will discuss the mentioned earlier non-refoulement rule. So starting from the economic migrants are those who cross border in a regular manner. They are not what is incorrectly called illegal migrants. Illegal migrants is a separate category of migrants, and they are protected by International Convention on the Protection of the Rights of Migrant Workers. This 1919 UN Convention seeks to specifically protect who migrate for economic reason and to work, but not with the view of settling permanently in the host states. The migrant might migrate because of the economical reason, because of the desire to connect with his or her family in the country, or for example, for the study purposes. Asylum seeker is a person who did apply for a refugee status and is in process of awaiting the decision regarding the refugee status. UN High Commissioner for Refugees was created in 1950 by the UN General Assembly, and given the remit that covered the protection of refugees worldwide. As we know, 1 year later, the Refugee Convention was adopted by the UN. The main reason for adoption of the convention was to have a legal instrument containing a general definition of who was to be considered as a refugee, and thus entitled to protection and their associated rights. Article 1 on 1951 convention include the three so-called provisions: inclusion provision, cessation provision, and exclusion provision. The inclusion provision inform us who is a refugee. According to the Article 1, refugee is a person who, owing to well-founded fear of being persecuted for reason of race, religion, nationality, membership of a particular social group, or political opinion, is outside the country of his nationality and is unable, or owing to such fear, is unwilling to avail himself of the protection of that country, or who, not having a nationality and being outside the country of his former habitual residence, as a result of such event, is unable, or owing to such fear, is unwilling to return it. So to become a refugee, we have to fulfill 5 requirements. The first one is alienage. Outside, it means that the person is outside of the country of origin. Difference between, this is a difference between the refugee and internally displaced person. The person has to feel well-founded fear. What is well-founded fear? We will explain in a bit. The person has to be in a risk of persecution. So any threat to life of physical freedom and serious violation of human rights will be considered as a risk of persecution. The grounds for persecution are race, religion, nationality, membership of a particular social group or political opinion. And also there has to be an availability of the state protection. Individuals first need to seek internal alternative for protection. But if the state is not able to protect the individuals, then they can become a refugee. What is well-founded fear? The convention test has both the so-called objective and subjective element. The decision maker must first ask a person applying for refugee status if the person is in fear. This is a subjective test and relates to the applicant's own understanding of the threat that he or she faces. However, there must be also this, the fear must be well-funded, and this requires an objective element. There must be objective reason for the individual's fear. So, for example, persecution of a certain religious group in the country is the objective element. The second is a cessation provision, which informs us how we can lose our refugee status. The first would be by voluntary act. So, for example, return to the country and change in the circumstances. When refugees are not anymore face persecution, but what is important to say that the change in the circumstances must be fundamental, must be real, must be sustainable, According to UNHCR, is the period for the change of the circumstances to really assess if the change was real, sustainable, and fundamental is around 12 to 18 months. The third one is an exclusion provision, which informs us about the people who fulfill all the requirements to become a refugee, but still can be denied of the status. So for example, if the person already received protection for another UN body, or already has a status in another country, like for example, people with a double nationality. We have also people who are undeserving the international protection for serious reason. So for example, to believe that the person was involved in crimes against peace, humanity, war crimes, or serious non-political crimes. It is also worth to note that individual can lose the refugee status. There are a number of grounds under this could happen. As we already said, it could be the voluntary act, if the person reavails himself of the protection of the country, of his nationality, or the reason for the fear of persecution no longer exists. The commission of certain crimes can also deprive an individual of a refugee status. Included in this are the war crimes and crimes against humanity, non-political crimes committed in the country from which he or she fled, or if the person has been guilty of acts contrary to the purposes and principles of the UN Charter. Now we will discuss the central tenet of the convention, of the Refugee Convention from 1951, the principle that a nation must not expel or return a refugee, so-called non-refoulement rule. In simple words, it means that state cannot return refugee. This is one of the reasons why states shifted the onus to those who provide transport. For example, under the terms of the Immigration and Asylum Act of 1999 in UK, any form of transport that arrives in UK, which is train, boat, aircraft, etc., requires the operator of such transport to ascertain correct and valid travel documents and permission to enter the UK. If a person arrives in the UK without such documents, the carrier is liable to a fine up to £2,000 per passenger. The non-refoulement rule is considered as a customary international law. In this sense, even countries which are not part of 1951 convention need to follow this rule. Article 33 of 1951 convention states that contracting state shall expel or return a refugee in any manner whatsoever to the frontiers of territories where his life or freedom would be threatened on account of his race, religion, nationality, membership of a particular social group, or political opinion. In this sense, non-refoulement rule prohibits deportation, expulsion, extradition, even not admission at the border is sometimes considered as an act against non-refoulement rule. Article 31 of the 1951 convention states that asylum seekers should not be penalized for illegal entry.